Thank you, Mr. Chairman. Coming down from the chair there, I almost thought about just walking out the door and going to grab lunch. But if I sound a little gravelly, I'm a little bit under the weather, and I sound a little bit like a monster truck rally announcer right now. But please forgive me. This bill we wrote last year in response to some concerns by stakeholders in the court system. And out of deference to some stakeholders in my community, we placed this on the interim agenda as a study item. And so it's been a long wait, but we're finally here where we get to discuss this issue. As I proceed here, probably the best way to preface this is to just talk about some of the perceived concerns and weaknesses that exist in our court system, and set the backdrop on why this proposal may be a good solution. One of the issues that affects our court system right now is a thing called trial de novo, and many of you as attorneys and judges in this room know what that means. But basically, as a summary, it allows a trial to be conducted twice without the second hearing of that trial to have knowledge or information from the first trial in helping determine the outcome of the second. And in our justice courts right now, since the courts are not of record, that status of being not of record means that information from the case is not considered when if the defendant chooses to have the case reheard in a higher court in what is currently the district court. When that case goes to the district court, the court does not have knowledge or cannot consider the information like an appeal would from the information that was gleaned in the justice court. So a trial de novo means a new trial. So what that means is that if you, for instance, right now, just as an example, let's say that an individual is caught in a DUI situation, and because the justice courts and the district courts both have jurisdiction over this kind of offense, the attorney for that defendant will go to the justice court to have their trial heard. If the outcome is not desirable to that defendant, they have the option to have that case heard again at the district court level. And the district court will start a brand new trial and conduct it as if the first trial didn't exist. This case has to be prosecuted twice, and that is something that the taxpayers of the state of Utah are paying for. And since there is not a true appeal in this sort of circumstance, there's a question of whether that is a good practice or not for the state to be involved in. And as I just mentioned, traditionally, going from the district court to the Supreme Court, there's an appeals process that can occur where the upper court or superior court will have review, or I like to consider it kind of a quality control on the verdicts that come from that lower court. Right now, as it currently stands, that does not exist in this appeal type format for justice courts. And so the trial de novo creates that blind appeal. So that is also a problem because the appeal process creates quality control. It creates peer review. So if I'm a judge, heaven forbid that ever be the case, if I'm a judge and I have a verdict and that case gets appealed, my peers who are trained like I am are going to review my work, and that has an effect on my reputation and standing as a good justice. And so that sort of feedback, if you want to call it, within the justice system is I think is good for our system and good for justice in general. Right now, our justice court system does not require, and we cannot require, our judges to be law trained. And yet, within our justice court system, we have misdemeanors, a serious allegation, DUI, domestic violence, those sorts of things that are being heard by justices that are not necessarily law trained. And that is something that we need to weigh as policymakers on whether or not that is a good thing. My thought is that while our Justice Court judges are good people and do good work, that there may be some specialization that will benefit and provide for better outcomes from these cases. And so, and we'll talk about this in the proposal. Just as I mentioned, the judges, and, they'll be dealing with things from parking tickets on up to misdemeanors, and so there's a very wide spectrum of cases they're hearing. Now, that's just covering the district courts, or the justice courts, excuse me. The district courts have a set of their own issues that have been brought up. We know that in the district courts that the family law cases are mostly being heard by commissioners that are overseen by judges. There have been a number of complaints about the commissioner system in general. The commissioners have been given authority, essentially, to act as judges, but they require the signature of an overseeing judge to execute the actions that they find for. And so there's the problem that seems to arise is the political economy related to the commissioners. The accountability there, where we have judges who are placed for retention elections, so they are directly accountable to the people periodically for their work. The commissioners are not accountable to the people. They're accountable to the Judicial Council, but not to the people. And yet they're given, from the perspective of the public, almost all the same authority and responsibility as a judge. And so that is a concern. Commissioners are not chosen the same way that judges in the district court are chosen. Judges are chosen through a nominating committee. They're vetted. They get sent over to the governor, who selects from a list of individuals, who then makes an appointment. That appointment then goes over to the Senate for further scrutiny and then confirmation by the Senate. Commissioners are simply chosen from a nominating committee and then appointed by the judge who will oversee them. And so the vetting is less, and again, not to cast aspersions on our commissioners or say that they're unworthy of the work that they do, but the way that the system is currently set up doesn't provide for the same level of accountability and scrutiny. Finally, the commissioner system creates some unique circumstances that may affect due process. In discussing and interviewing with stakeholders, I've been made aware of situations in the 3rd District here where commissioners are not requiring testimony from witnesses to occur in family law cases, where they will the attorneys will proffer evidence, and they just have affidavits, and they give affidavits to the commissioner, who will then review them and make a finding based on that, without requiring any sworn testimony or witnesses to be present at those kind of cases. I have to ask whether or not that is good practice, given the sensitivity of family law and the impacts and echoes that it has through time in families' lives. Is there a better way to deal with that kind of situation? And so, with these concerns in mind, we took a look at all these issues, and if we fix one thing, it seemed to affect another, and you push the balloon in one side and it pops out the other end. So we deliberated and came up with a proposal that seems to cure most of these problems in a very straightforward way, and that is the circuit court proposal. And that proposal would institute a second tier within our courts of record. So we would have a circuit court that would have appeal. It would appeal up to the district court. In your packet here, I give you the bill at a glance, so you don't have to read through every line of it in our committee meeting today, but I kind of give us a summary. Essentially, it creates a mirror of our current district court system, this bill. And the Judicial Council and the presiding judge of the circuit court would select staff. This bill would move misdemeanors out of justice courts and district courts and place them in the new circuit courts. So we would have a judge in the circuit court hearing misdemeanors. The court would also handle family law. And so conceptually, we would have judges, not commissioners, hearing family law cases in the circuit court system. It is highly probable that the commissioners that are in our current system would apply as judges for the circuit court, since that is their field of expertise and their specialization. Except the difference, of course, being is that their nomination and accountability would be, they'd have further scrutiny and more accountability to the people, since they'll be justices in the court. The state would pay for the cost of the circuit court. That's probably the big asterisk on this proposal, since I have not submitted this bill to our fiscal analysts yet, pending your input, so that we can find out what this would cost. There are a few moving parts that we would have to determine would be necessary to do this. And I'm not going to throw a number out there because I don't want to spook the crowd, but it could be, it's going to be more than $1 million, most likely. Less than 100. So somewhere in that range. So as far as fees go for fines and whatnot, the bill delineates where those funds go. It'll basically be a 50-50 split for most fines, except for a few. There's a few exceptions for some interesting transportation caveats and whatnot in the bill that have to be there per statute. But other than that, that is what the bill does. And so if we flip over to, I just wanted to review some of the data with you, because I took a deep dive into our statistics with our courts, went online and started scouring the numbers and figuring out where we're at. On the second page there, you'll see what percentage of criminal cases are filed in justice courts in various counties across the state. Rich County has the highest percentage, although it's a very low caseload court. Weber County, where I'm from, is about 15%. Salt Lake County is a little higher, about 17-18%. The next page takes an aggregate of the state and puts it in a pie chart for us. So you can see that about 79% of all cases heard in traffic court, or in, justice court, are traffic and parking related. You've got small claims, civil cases at almost 6%, and then about 15% on average as far as criminal cases, which we would assume to be misdemeanors. That 15% would be the number of cases affected by this bill. So these cases, that wedge there, would be removed from the justice courts and placed in circuit court jurisdiction. And if you have time and want to put yourself to sleep, you can look at the tables that I put together. But this is the data that I drew from to make the charts, just so you guys know where that is coming from. The next chart or table I was looking at here is actually graph, correct word, is the number of domestic family law cases heard in Utah's district courts. That's the one with the bars on it here. As you can see, Salt Lake County is taking in, and that makes sense based on population, it takes in the bulk of the cases for the state, just over 6,500 family law cases heard each year. Interestingly also, we have a number of other courts, and perhaps Mr. Schwimmer can address some of the whys and hows of this, but we have a number of courts within different counties that are populous but not dealing with any family law cases at all. You look at the very end of the chart out there, zero is Davis County, Layton, Davis, Bountiful, Daggett County. No cases like this are heard in those courts. And so, again, this will show you the number of cases that would be brought into the circuit court system. Kind of give us an idea of workload. Okay, the next pie chart we have deals with cases filed in the Utah district courts. So we're looking at district courts. What kind of cases are they dealing with? Well, it turns out 36% of them are judgments, collections, that kind of thing. 29% would be civil. Your criminal aspect, this kind of surprised me, is only about 12.5% of district court work is criminal work. And they're dealing with murders, homicide, acts of violence. The only caveat here with this chart is that the statistics I have did not break down which cases were misdemeanors and DUI, which would be affected by this, and which were felony. I'm assuming it's going to be a fairly small percentage, but I don't have that number. But just truth in advertising here. So what I also did was I took all the cases. I looked at the whole universe of cases filed in Utah court system, and how many were there? There were a little over 800,000. And then I took the number of cases that were held in each category in the district courts and all that were held in the justice courts, and put them in this pie graph showing you where they were and what percentage of the caseload in the state is what kind of case. And you can see that still 51% of all cases heard in the state are justice court traffic parking violations. And then we whittle down to smaller wedges, with district court civil being 10% and the next largest being district court judgments. In any case, the reason I put this together is so that you can see the wedges that would be affected by this bill. So we're effectively going to pull out domestic, excuse me, I'm looking at my chart here. Oh, yes, domestic issues, which is 4%. And we're going to be pulling out justice court criminal cases, which are 10%, and put those together. So you flip the page, and I color-coded it so you can kind of see and get a feel for it. So the orangey warm colors are your justice courts. The bluish cool hues are your district court, and the green would be the new circuit court caseload. So you'd be about 13, 14% of Utah's caseload would be handled by the circuit courts. Mm-hmm. And of course, not all cases are created alike. Parking tickets take a little less time than family law issues and those kind of things. But just wanted to give you some perspective, at least based on the data that I had collected. One of the criticisms of this proposal is the cost, and some things to consider with that. Last year, the legislature appropriated $240,000 to hire a new judge and support staff. I don't know the exact details of what staff was hired to support that judge, but I used that as a benchmark to indicate what a judge is going to cost for the circuit court. And then I also assumed that we were going to lose some commissioners who would become circuit court judges. The average commissioner that I could determine based on the right to know information was that a commissioner is paid about $150,000 to $165,000 a year for their work. And so to create a new judge and a new court will cost about $70,000 of new taxpayer money to do that. This bill calls for hiring judges that mirror the district court template. So there will be about 35 judges hired. And so I'll let you do the math on that. That's it's around $3 million of salary, new salary, if that substitution was perfectly straight across. And one of the purposes of sending this bill to our fiscal analyst is to determine what that number really would be. There's been some discussion about creating or building new buildings. I suggested we make them out of paper mache to keep the cost down. Nobody liked that idea. So one of the things also in seriousness though, to consider that pie chart that shows the universe of cases heard in our state. Those cases are all heard in a building somewhere. And you notice that pie wedge didn't grow in size. We just moved the wedges around. So it means that if family law cases are no longer being heard in the district court, there is vacant space at a certain time of day in that district court. Logistically, I believe that we could save money by grouping or scheduling those buildings to accommodate that. Obviously, in rural locations, that's going to be a little bit more, take a little bit more work to figure out. But here in the urban centers, that should be pretty straightforward. It's just a scheduling issue and logistics. But with that, my purpose here is to have a discussion with you and to put these ideas out there. I guess to debate the merit of these arguments, and I'm open to any feedback or suggestions that the committee has, because I know that your legal minds are more brilliant than mine. So with that, I conclude my presentation.
All right, thank you, Representative. I'm going to take the liberty of telling a quick story that I'm reminded of when you gave us that $1 million approximation. Some years ago, our family constructed a summer home at Fish Lake, and my parents had never been there till we finished, and my father was advanced years, and he came inside and looked up at the beams, and he just shook his head, and I said, "You okay?" And he said, "You've spent all of $20,000 on this." And I said, "All of it, Dad." All right, I'll go to Representative Christensen.
If I might, Mr. Chair, I just have some miscellaneous feedback that you can maybe add to it. Would that be okay? I could just share a few observations, just in random order, but these are based on firsthand experiences and observations as well. With regard to the justice court system, as I understand it, what I've witnessed, it's primarily at the city level, and some of the things that frustrate people, and I know the judges, I've talked to several of them, and they feel a little bit on edge. They feel unappreciated, I'm sure, and the city attorneys can relate to some of this. But to the citizens, to the defendants who walk in, for many of them, it's the only court experience they'll ever have in their lifetime. And they walk in having been taught in school that you're innocent till you're proven guilty. They walk in on a traffic matter, which your pie chart shows is the bulk of what they do, 70-some%. But there's a judge that is appointed by the mayor and the city council. There's a city prosecutor, and then there's the police. And they're there Monday through Friday, every day of the week. And the defendant many times feel that they're the only one in the room that isn't on a first-name basis and recurring and everything else. So there's a lot of them feel understandably very much on edge. Respectfully, the trial de novo is the one thing that gives them an opportunity as an option, but they usually have to go hire an attorney, go to another court. So it tends to sift itself out. But that's just one thought.
Could I respond to that? The trial de novo would still be in place for these traffic type violations. It wouldn't apply to the misdemeanors, which the jurisdiction of the justice court would no longer have purview over.
Well, most of the cases settle if for no other reason than, and two things that are acting, whether we like them or not, but I think that the court people, knowing that there is a trial de novo out there, makes them feel like that, that it kind of motivates them to maybe try to reach a settlement agreement. And then on the other side, the defense side, the citizen says, do I really want to spend all this money, to keep going and going to have that moral victory? And one of the things that troubles me, and Mr. Schwirmer knows, we talked about it this morning, is that I'm over here advocating, a right to a jury trial when your parental rights are going to be terminated. Your God-given natural parental rights, and you don't even have a right to a jury trial, but you do in some of the most smallest misdemeanors, and yet you get a jury trial. For a civil case over $20 in damages under the Seventh Amendment, you can get a jury trial. But, so that's just something that we're talking about separately that I think is a flaw. If you look to California as an example, they currently have their municipal courts and their superior courts, which would be just a different terminology for your circuit in your district. They have problems where things get plea bargained, but if you go in and you get dismissed, that felony count, then all of a sudden they don't know what to do because one case gets dismissed at one level, has to be refiled at the other level. So there's a little bit of confusion. One of the things in family law that I think California is pretty interesting in, and I remember back when I was in law school and was a judicial law clerk, this was pretty informative back then. But I remember getting a call down in the law library from the wonderful, wonderful judge. And he said, LeVar, we're on recess on a jury trial, but I just got assigned to a real estate matter. I know nothing about real estate. Get up here quick. And behind the scenes, well, in reverse, I saw a case just recently. We have a new judge here in Utah that's only been in maybe 1 or 2 years, but he knows nothing about family law to speak of from day one. It wasn't his background, but he's got a commissioner with over 20 years of experience with family law. And so one of the things that California does is they have a family law division within their entire superior court, and sometimes it's the newer judges, but you might, rather than just have random assignments of family law cases that are all over the place, you might want to, without creating a whole new layer of courts or 2 papier-mâché courthouses, you might want to consider a family law division, rethinking. And there is a push, internal push. Many people feel that the commissioner system is not working, that it's an added layer. It's almost like a planning commission and a city council. Many people feel that they're an advisory body, but after a while they wonder sometimes how they feel about it. It vets, it screens. But some people think that maybe you should not have the commissioner system, but maybe pick some of your best commissioners and they become judges. And there's some discussion going on about that. But perhaps the family law division, and Mr. Schwimmer would know best, but maybe the idea of whether you have family law, which is such a huge part of this, rather than have it just randomly spread out over every district court judge gets a certain number of family law cases, regardless of their background or how long they've done it. That's just a thought. And then I think it's pretty refreshing that if you look, I think it's been, how long has it been, 20 plus years that we've had a court of appeals, but for the longest time in Utah we didn't. I remember one of the very first cases I ever did coming out of law school, it was Justice Durham right before she was appointed, midstream, in the middle of the trial, she was appointed to the Supreme Court. But the case was ultimately decided based on a 1909 Wisconsin case and a citation from Amjur. We didn't have much Utah precedent at the time. Yeah. And so I just wonder, as we look at the evolution, and the last thing is that the juvenile versus district court, they already have concurrent jurisdiction, and it's causing some problems. People are going forward with divorces, and then there are certain allegations that can surface and that can refer over into juvenile court. And then so there's some internal tension already between the juvenile court system and the divorce courts. Those are miscellaneous observations. So I think you've identified, Representative, I think you've identified a lot of legitimate questions and issues, but I think there's so many stakeholders. I can see nodding heads, shaking heads, rolling eyes, whatever, and I think that, but if you get everybody together, there might be a cost-effective, judicially efficient way to address some of these concerns, and it may not be the circuit court system, but I think you're doing a good job of troubleshooting.
Well, if I've provoked a response from everybody here in the room, I've done a good job. So.
There you go. But I think our chair had some feedback.
Well, let me just remind us that we have a special session of the legislature that's been called by the governor, so we need to be fairly efficient with our use of times. I want to hear everybody who has a comment, but if it's not a question, I'd rather save it till after we hear from Mr. Schwimmer. We ask him to come specifically to give us a little historical reminder. We had a circuit court system. We moved from that. He can share perspectives on that. But if there's a question for Representative Peterson right now, I'm glad to hear it. You want to?
It could be now.
All right. Why don't we? Do you have a question that needs to be asked now, Representative Hall?
Not now.
All right.
Eventually, yeah.
Why don't we hear from you, Mr. Schwirmer, and then we'll come back to the questions.
Thank you. Just have to get closer. Thank you. And I know we're short of time. I don't know how much time you want to take. I assume you want the really short version.
Yeah, well, no, we need to recess by 12:45 is the absolute maximum, latest.
Wow, you got more time.
But
than
we
I
got a
thought.
little time. We want to hear what you have to say because you have a lot of background, so.
Well, and
Please
it may be time best spent to answer questions to be sure that you all understand what you want to understand. But with respect to what you asked me to do, Mr. Chairman, which was give a little bit of history, let me just say that, first of all, and I take no personal pride in saying this, but I think 49 other states look to Utah as having pretty much the best managed, best court system in the country. And that's just the fact. That's just what happens when you go to other states and talk with legislators, executive branch folks, and courts, is we have probably the most efficient court system in the country. I was in a cab on the way to the airport with a judge from Minnesota Monday, and he was reminding me of that conclusion and that perception. So with that background, let me also explain that we are where we are, and we are structured how we're structured, not by accident. We have a good tradition in Utah of studying these kinds of issues very carefully and very collaboratively. So let me just in the way of history, first point to a 1972 study called Utah Courts Tomorrow, Report and Recommendations of the Unified Court Advisory Committee. And this was a legislatively staffed commission that had the commission itself was entirely legislators. And then they had some ad hoc members who were judges and others to advise them on court unification. And the principle that came out of that study, that broad, big picture, 30,000-foot study, was that we need to have fewer levels of court in Utah rather than more. In 1972, we had city courts, we had county courts, we had justices of the peace courts, we had district courts, juvenile courts, and their conclusion was we should have one trial level court. And what that really led to was the elimination of the city courts and the assumption by the state, because most of those courts were local, the assumption by the state in 1977, 78, of a large chunk of that court workload into what was then called the circuit courts. So the circuit courts were created in the late 70s, really as part of a court unification effort and an effort to put the state in control of the costs, the responsibility, the quality, oversight of our courts rather than local government for most cases. The circuit courts heard Class A misdemeanors. They were magistrates, so they heard preliminary hearings. They heard B and C misdemeanors, and they heard civil cases under, first it was 10,000, later it was changed to 20,000. The next time we all got together and studied these issues was from 1988 until 1991. There was the Commission on Justice in the 21st Century, which was, again, a collaborative, big-picture look at where should we be going by the year 2000. And it included a court organization subcommittee to look at these issues that had judges, legislators, Roy Simmons, members of the public, all kinds of folks, Lyle Hilliard, Lorraine McAllister, Craig Moody, Byron Harward, Hayes Hunter. For some of you, this was sort of a memory. This was my first year working for the courts, was helping to staff this committee. And one of the things I noticed is that when we just sort of look back at the cold record of what things looked like, what statutes looked like back in the day, if the day is 1990, I was there and I remember it, and I can hopefully help give some perspective on what things really looked like and why we came out with what we came out with. So what that commission said basically was, we need to get rid of the circuit courts, because that's another level of inefficiency, it's another level of government, it's another level of bureaucracy that does not serve the public well, and certainly does not serve the state general fund well. And they wanted a higher quality of jurist. I mean, circuit judges were folks who couldn't get district judge jobs. And so they proposed getting rid of the circuit court, which left you with two in the adult world courts. The local courts, which our history, tradition, and constitution recognize, which we then changed the name of to emphasize how different they were going to be, from justice of the peace courts to justice courts. And when that shift happened, after the change in the judicial article in 1985-86, and after this happened, 1990, 1991, was enormous. And some of what those changes are on this, I guess, gray sheet, and we don't have time to go through it, but just feature yourself sitting in front of a JP, which I view as sort of a derogatory term, and appropriately so. A JP, when I got a ticket in 1990, I went to the JP and wherever he was in Utah County, because I'd been in the canyon going to Price, and we sat in his living room. And prior to that, he had been paid, by the way he was compensated was he got a fee for every conviction. He got a fee for every ticket and an extra $1.50 if there was a conviction. Is that fair? Of course not. So the sea change from 1984 through 1991, let's say, was enormous, where all of a sudden we moved these JPs out of their kitchens into public facilities, required training, standards, staff, all kinds of things. That was an enormous step. And that took the place of sort of the lower half of what circuit courts were doing. And the rest of what circuit courts were doing went to the district courts. The other example that I'll give you, just in the way of a real-life story at the time, was in 5th District at this time in 1991, when the legislature was debating the abolition of the circuit courts. We had one district judge, and we had 2 circuit judges. Okay, district judge could do everything. Circuit judges could only do this flavor of case, these misdemeanors and this small civil. Well, the workload didn't match. The workload said what we needed were 2 district judges and 1 circuit judge. But we didn't have 2 district judges. So we had to come to the legislature, and we had come in 1990 saying, could we please have another district judge in 5th District? Well, do you need it? Well, yes. Well, how many judges do you need all told? 3. How many do you have? 3. You'd like us to give you a 4th judge, though, right? Right, because these judges can't help with the work that we actually have here. Well, that doesn't make any sense. If you need 3 judges and you have 3 judges, everyone's good. Why do you want us to pay another $250,000 to create a 4th judgeship? Because we have to, because certain judges can only do certain things. That's the danger of divisions and multiple court levels. So based on that and the rest of the justification from this study, we got rid of circuit courts. Okay? So that's sort of the historical perspective. I'm not sure if you want to hear more about that, other than the reasons were efficiency, judicial economy, cost, public access. And as we have these conversations, always remember that while you may be thinking of Salt Lake City, don't forget about Duchesne or even St. George and how these different proposals affect these different places. Some of these things, for example, I was thinking of Rich County as I'm looking at my friend here, who certainly knows the sheriff in Rich County well. And right now, the sheriff in Rich County has to cover juvenile court once a month and district court once a month. And now if we add a circuit court, guess what? He's got to come back 3 times. That he's going to have to come provide bailiff services, transport prisoners. I mean, there are things like that that are just antithetical to the movement we have had over the last 3 decades, 4 decades, that concern me about this bill. But I'm glad to
Mr. Chair.
I'd like you
stop and
to,
take
I'd like
questions or whatever you like at this point.
address the evolution in the justice courts and what steps have been taken, and successes that have been achieved, if you think that's accurate.
As I say, mostly they're on, I think it's gray, the sheet that I handed out, that just gives you some idea over a couple of different areas of what was happening pre-1990, what was happening between 1990 and 2008, and what happened in 2008, 2009, and subsequent to that. Because we certainly recognize some of the problems that Representative Peterson has alluded to with respect particularly to the perception of justice courts. And understand that we have a particular sensitivity. I think I talked a little bit about it last meeting. It doesn't matter if this judge is fair and doing a good job of applying the law to the facts. A lot of what's more important than that is he perceived as being fair and just applying the law to the facts and giving a just determination. So whether there was really sort of the cash cow or the money grubbing and all of that going on in 2007 or not, there was a perception that there was. And our response to that was, again, a 3-year study. I talked about this a little last time, but that made some fundamental structural changes in justice courts. And again, collaboratively, Roger too, Adam with the counties, we all came together and came up with something that we could all live with that addressed what we agreed to be perception issues and came up with a system that worked okay for everybody. Nobody got everything, but it worked okay. And so the changes we made were not so much with respect to jurisdiction, but we made fundamental changes in the way that judges were selected, retained, compensated, the standards that apply to them, the state's role with respect to justice court judges, and you can see some of the numbers that are here as well. The point being that all of those structural changes were intended to and did give judges more autonomy and separation from local government. Because the problem was, and is, while these are local courts, we still expect them to be independent. And so the way to address that was to be sure that they cannot be, they're not hired because somebody thinks they're going to raise the city or county lots of money, fired because they didn't raise enough money, fired because they found the mayor's nephew guilty of DUI, whatever it is. Those were the structural changes that were put in place, and they have made huge differences. And I agree with some of the comments that you heard last time where judges said, I was afraid that I'd get called in. Well, I'm Senator Weiler, in the meeting that he talked about. I know that there were those conversations where people got called in to explain why they let somebody off the hook or didn't get a fine or forgave a fine in lieu of them applying it to treatment or whatever else it was. I know those happened, but they can't happen now because that mayor, that county commission doesn't have the leverage anymore. So that's what we've done to fix it. Again, I can speak to a few more of these details if you like, but I think maybe more important is to look at the last one, the numbers, 2009 to present. You know, we have 134 justice courts out there with 98 judges. By the way, almost half of them are now attorneys. Because of the compensation changes we made, the makeup of the justice courts is changing drastically. The Constitution says we can't require them to be attorneys, but because, for example, there is only the one attorney in Daggett County and we need a judge and he can't be the prosecutor. I mean, there are reasons in our state why we can't do that. But by the way, let me just, one other thing that kind of gets under my skin and that of some of my judges is to say that they're not law trained. They're law trained. They have double the CLE, for, if you will, requirements of a lawyer. They have to have 30 hours of continuing judicial education every year. Are they lawyers? Half of them are, half of them aren't. And by the way, if you charge me with a crime and I get to pick which judge hears my offense, it may well not be one of my lawyer judges. Because frankly, I'm a lawyer. What does law school teach you to do? Get around rules, right? Use them to your advantage. Disregard them if and when you can. And then you have a lay person and you give them a robe and a gavel, and they are scared to death. Not all of them, admittedly, but the vast majority are scared to death of violating any rule that I've ever explained to them or any recommendation that I've ever taught them about how to sentence, how to conduct court. They're some of the most conscientious folks you will see. So those are the changes that we've made. Those are the changes that we've implemented. And I think, was there one piece left on the table with the changes in 2008, 2009? Yeah. To go all the way to fix the problems from our perspective, you would have said that all of the judges were going to be full-time, not part-time, because we have some judges who hold court maybe once a month. I mean, court's scheduled once a month, and if anybody shows up, they're there, and if not, they don't. How proficient can you be at your job if you do it 30 hours a year training and a couple hours a year doing? So part of the proposal that got stripped away, and that's fine, that was the legislature's choice and local government's choice, was make them all full-time and make them all paid directly by the state instead of through the local governments. And there's still that on the table, but I don't, that's a policy call to some extent for you all to make if you still think we need to go that extra step.
All right, thank you so much. I'm going to come to the committee for questions. Representative Perry?
Thank you, Mr. Chairman. The question I have actually goes into one of the things that Representative Peterson brought up, and that is with these commissioners. How do we hold them responsible for the things that they're doing? We have obviously a signing judge. Should we just put it in there and it says, hey, we're going to put out if a commissioner gets a number of complaints, whoever the signing judge is now responsible for them, and so we can kick them out of office in the process? How do we solve that problem? I'm just looking for a solution to it because we have that problem. I know of at least 2 examples in my own area where we have numerous complaints on the commissioner, and the judge's answer is we like the judge or we like the commissioner because he gets things done. And I struggle with that because if you're getting complaints on him, we have to solve that problem, and there's no ramification for the citizens to solve it because the judges are like, hey, we can do what we want to do.
Yeah, and I appreciate that perspective, and there are a couple of responses. One is, I've heard complaints about legislators. That doesn't mean we need to get rid of the legislator. I've heard complaints about troopers. We don't need to get rid of the trooper. Do we have a system in place? Do we have a process in place to look at the conduct of that commissioner and address what needs to be addressed? Yes. If it's legal ability or a decision, it's the easiest thing in the world. All you do is object. I object to the recommendation because commissioners don't make decisions. They make recommendations. And if you object to the recommendation, that's simple. You simply send a note to the judge that says, I object, and the judge reviews that recommendation from that commissioner. Admittedly, they get different levels of scrutiny, but there is a process for reviewing the legal decision. Is that judge doing something unethical? Bring it to we have a Commissioner Conduct Committee that I happen to staff that is exactly the same as the Judicial Conduct Commission, in the sense that it's independent folks who come in and have the ability to investigate, look at things, and remove that commissioner if there's a problem. Judges have a certain measure of judicial independence. Commissioners actually have less. And it's easier to get rid of a commissioner than it is a judge, by far. And so if there are problems that rise to that level, we can solve them easier if they're a court employee, commissioner, quasi-judicial official, than if they are an Article 8 judge with a whole bunch more protections.
Great, thanks.
Sure.
Thank you, Representative Green.
Thanks. A couple of questions, clarification. Either one of you can answer. But in listening to the presentation by Representative Peterson, it seemed to me that there were a couple of erroneous assumptions in the presentation. The first is that the Justice Court subject matter, the jurisdiction over which the Justice Courts currently have, the subject matter over which Justice Courts currently have jurisdiction, some of that, particularly the criminal, will be going away. And I see between the 2 pie charts here, you don't have page numbers, but the as is and then the proposed, that the district court, other than what one was it? Domestic, the figures don't change, the percentages don't change. So it seems to me that there's an underlying assumption that there's a justice court in every jurisdiction. And so when we create these circuit courts, we would be taking that subject matter from the justice courts. But where we don't have justice courts currently, those matters, even traffic and parking and code violations, are handled in the district court. So isn't it true that all of that caseload would be moved from the district court to the circuit?
This is a very rough, I mean, the bill says that if there's a circuit court is unavailable to hear cases, they'll be heard in the district court. I mean, so that is, there's some overlap if the circuit court isn't available to hear those cases. That's not represented here in the pie chart. This is a very rough, trying to just give us a conceptual idea of where the movement of caseload will go from a whole statewide level. And there was some minutia in the detail of information I had that I couldn't put that in here. But
Okay, Mr. Schwimmer.
Could I also respond to what specifically you're asking? There is a justice court everywhere except in unincorporated Cache County. Don't ask why, it's a long story. So that's why the numbers wouldn't change much.
Okay.
But what you point out, and where I thought you were going, is the problem with those numbers and some of these assumptions and the drafting is that we use criminal and traffic for purposes of putting it out on a public website in a pretty loose fashion. Mm-hmm. You get that 9 over speeding is a Class C misdemeanor.
That was my second erroneous assumption, is that this would require an overhaul of our criminal code to move all of those traffic violations out of the misdemeanor classification into an infraction only, or at least the vast majority of them. Otherwise, if a justice court doesn't have jurisdiction, no longer has jurisdiction under this new proposal over misdemeanors, they couldn't even hear those traffic violations.
Well, there are three things. There are criminal cases. A criminal means anything that carries the potential jail as a punishment. So that's Class C, all Class Cs, Bs, and that's pretty much everything. Mm-hmm. We have a few infractions which are part of the criminal code, but the punishment for an infraction cannot include jail. But then we throw in this term ordinances, city and county ordinances. Well, guess what? There are civil ordinances. We talked about that last time with Salt Lake City parking. But there are also criminal ordinances. Cities and counties have the ability to adopt ordinances with a penalty up to a Class B misdemeanor. There are counties out there where you are not charged with speeding 41-6A, whatever. You're charged with county ordinance for lack of for ease of numbering, 41-6A, whatever. But you're charged under the ordinance. So what this bill actually does is give local government complete discretion to determine whether basically none of these cases go to this circuit court, or basically all of them go to this circuit court, depending on how they choose to categorize their cases. I suspect that what the sponsor would prefer to do is to make the decision for them and either bring them all or leave them all. But that impacts the fiscal note greatly.
Thank you.
Amen.
All right, thanks. Representative Christensen, your question.
Just one question. Rick, as you gave the evolution over the last 20, 30 years, do you see any merit to the idea of a consolidated family law division? And I know in California they also have criminal law division. So they congregate the judges that have accumulated expertise in that area rather than just fan out all subject matters of all filings and everyone gets their piecemeal assignments. But on family law specifically, do you see any merit to that, and has that been a topic of discussion?
It has. The Judicial Council studied it long and hard and came up with the conclusion that we should not adopt a family court. What they called a family court was basically a merging of parts of what is now juvenile court and along with domestic. There are a lot of reasons. Let me give you one practical and one theoretical.
Think about division as opposed, not just a word, but think about a division rather than a new court.
Same general concept, though. One is both of these specifically say reduce divisions, and they use the word divisions as much as possible. The more you create these artificial lines of you have the authority to do that and you don't, you end up with our 5th District St. George issue of wrong flavor of judge. Right number of resources, just the wrong flavor. So you increase the likelihood of that, and while you and I could probably envision how we would make that work in Salt Lake City, let's go to Duchesne, where there is one juvenile judge and 2 district judges, and how are you going to do divisions or any kind of specialization there? So the hybrid that we came up with is that we have, just for this issue of domestic divorce-related matters, we do have specialists. We call them court commissioners. They're quasi-judicial officers. And by the way, they are only in 4 of our 8 judicial districts, and they only do preliminary determinations.
One of the
That's
things,
kind
one of the
compromise
things you're
we
running
came up
into there, Mr. Chair, is that because the system is so slow, you end up going with temporary orders, and temporary order can last for up to 2 years. And so you'll get into it. But as a practical matter, does the presiding judge make all of the assignments? And behind the scenes, is it, we don't know, we just get a notification that such and such a judge was assigned to your case. But as a practical matter, are some of the assignments made based on who knows the nature of this? So it is pretty random, isn't it?
Computer does it.
Okay, thanks.
Senator Madsen?
Thank you, Mr. Chair. A couple comments and maybe questions. First, whenever somebody says, Utah's ranked #1, I remember Senator Stevenson's comment that it's like being the tallest building in Tooele.
I love that too.
And frankly, I'm not as concerned with what the citizens of 49 other states think about our system. I'm mostly concerned about what the citizens in our state think about our system. And I don't, you may have said we're #1, but I don't think you said we've reached perfection.
Most.
Okay, all right.
But we do have actually lots of public surveys where we ask our Utah citizens, how are we doing? And I'm glad to share that with you. I haven't in the past because, frankly, Senator, we came out way above the legislature. So, but we've asked them, and they do think we're doing a pretty darn good job.
No, I don't doubt that at all. The legislature comes below the courts. I think more people are aware of what their legislature is doing than just even interact with the courts. So that might have something to do with it. But I'm interested in the history of this, and in all senses. I was asking my co-chair, aren't they called circuit courts? Because in the day they used to ride a circuit, and the judges would go to different places, and we might somewhat, if this were to go through, harken back to that. But I was interested in the studies that were done over time. And the value of those. It is a snapshot in time, but it's an opportunity to bring people together that have perspective and to take a holistic approach and holistic look. And interested in the timing. They seem to be about every generation, or 20 years apart. You had mentioned the early 70s, then it kind of bleeds over late 80s, early 90s. And it seems like we may be overdue for another. I know that there have been some adjustments made to the justice courts after there was a hue and cry, but that may or may not work well and interact well with the rest of the system. And some of this now gets into my question for the representative, but and I guess it is my question. You've identified problems, and there's a lot of attention been paid to the justice court problems, and I think that actually the current concerns are misplaced. I think the pressure now and the structure of compensation is more directed at the prosecutors, the city prosecutors, by city law enforcement. I don't like this guy. We've got to pursue this person. We can't drop we can't dismiss. How are our prosecutors compensated? Is it, so I think that's the problem now, and any discussion about the judges per se is misplaced because of the corrections that have been made. But I think that we still have problems with the motivations of the players and so forth. But again, looking at the history, looking at the studies and the timing, I wonder if the concerns, and I'm more concerned about the family law. I think I've got more complaints, and I don't know if you break down your surveys and if people are as happy with the decisions coming out of the family law sector versus the other sectors. But we get a lot of feedback. As the hated legislature, we still get feedback from the people, and there is dissatisfaction with the way the justice that is received out of the family law courts. And so, but I guess my given that, would it be time to have another commission? Would this bill possibly be the baseline and morph into another commission where we would get a group of people and give them the same opportunity in the realities that confront us now versus relying on the realities that were in existence 3 decades ago or 4 decades ago? Look at because we may have learned
we may have progressed. You know, I don't know Representative Peterson very well, and given his presentation, I couldn't tell if he was an attorney or an economist or an interior decorator. Well, with the cool colors and the warm colors in the eyes, I don't know.
All three, actually.
But it was interesting, and he spoke again as an economist at times, and those of us who've had training in economics understand, you know, when we efficiencies and specialization and so forth. So I wonder if, regardless of what the other 49 states think, I believe that we still have not reached perfection. Yep. Given the history, it seems like we're about due for a real in-depth, holistic look at our courts. Yep. in the current day. I think there's value to that. I think that we will do a service to those who will follow after us in 10 or 20 years if we take an opportunity to step back and to go through that process now and look if we can't become closer to perfection or learn from, again, I think we're maybe moving in the right direction. Maybe the pendulum has swung too far, but we do have problems. I applaud the representative, and I think, again, the principle of checks and balances in the system is critical, in whether it's the hated legislature or the beloved judiciary. We've got to have those checks and balances in the system, and I think, based on the testimony, those are lacking or could be improved.
Yeah. Can I comment? I think that's a very, very good comment, and I was having a similar thought, although if we can just wait, 3, 2, 1, wait for Gerke's tweet on the internal, oh, there it is, okay, on the interior design.
Yeah.
I'm sure he said it out. But second, you know, I half agree and half disagree. The reason that we had to go through this in 1970 and the reason we had to go through it again at some length around 1990 was because there were still big pieces to be moved, because we were moving from, you know, to some extent an English model, and from some extent a local to state control kind of, we had those issues. So there were big options out there. I'm not sure that there are big structural options left. I mean, there are only so many things you can do. But that being said, what we have done is we have done big, inclusive, including legislators, studies of, for example, as you mentioned, largely in the area of domestic. We did that first looking at the family court, but the legislature has undertaken it. I mean, got more years, Senator, Hilliard's here. Other than him, I've got more years with this committee to reflect on all the times when this committee has ended up spending half of its interim, although Esther's been here, on domestic issues. What do we do with divorce? What do we do with commissioners? What do we do with custody? What do we do with, all of those issues have perennially been before this committee. Lieutenant Governor Bell took 2 years to just sort of pull everybody aside and do a study on that over the course of 2 years, looking just at those issues. So we've done them more recently in isolated topics: domestic, family law, justice courts that turned into this big change, some of the juvenile court things. We certainly, with Representative Christensen's help, look at child welfare every year, structurally as well as policy-wise. So we've done it on a smaller basis. Whether we need to either A, look at domestic issues again, collectively, or B, step back and see if there are any other parts that can or should be moved, is certainly within your prerogative, and we would hope that we would all participate together if you think that that's a good thing to do. So 2 different ways of approaching it, neither one is...
Well, and I'm mostly interested in the sponsors' thoughts about that, because I agree with every shortcoming and every challenge that you've identified here.
Yeah.
So go ahead.
I'm going to take 2 more questions. We're Representative Snow and Representative Arendt.
I've shut off my light. I'll withdraw that with all due respect.
Thank you, Representative Arendt.
Hungry, so.
Actually, I don't think we have time, given the time right now, to get into where I wanted to go. I also would like to have heard from some other people that have some historical perspective. I see Roger, too, here, who's been through many of these issues before. Others I would like to hear from, but given the time, I think I will withdraw that for now.
Yeah.
All right. Thank you so much. Representative Hall, haven't heard from you. Did you have something pressing?
Yeah, I don't know that you need to answer this question now, but of course, what you're proposing is a pretty fundamental change to the structure of the court system, and and we can talk later about this, but would you consider piecemealing parts of these concerns and addressing one at a time type of thing?
Yeah, I would be open to that approach. I would be.
All right. I know I have other players in the audience. Any 15-second comment?
Drive by.
Chairman, I'm Greg Hall Sr., and with Senator Hilliard and myself and Rick, I've got 30 years of experience
Yeah, come on.
as a city attorney, working with justice courts, city courts. And I think we need to have a serious discussion, not only about what Representative Peterson has mentioned, but we have an issue regarding surcharges that the state mandates for justice courts to collect. I'd like that to be included in anything that Senator Madsen or the representative has in a study session. For example, between 35 and 40% of all fines that justice courts collect go directly to the state. That's an issue with justice courts. The two cities I represent, Midvale and Holiday, in fiscal year 2011-2012, between those two cities, they remitted over $1 million in surcharges to the state.
All right. Thank you so much.
Thank you.
We're just out of time, folks. We've done our best. I've lived through this in both branches, the judicial branch and the legislative branch. We're probably better off now than we've ever been in my experience, which dates back a lot of years. So we look at it again.
Well, that was going to be my, I was going to ask the chair and vice chair if perhaps we can put this item on the agenda next month for maybe another 20 minutes of discussion, if that's appropriate. Since we haven't had an opportunity to really hear from you.
I'll talk with you about that.
Okay, over lunch.
Right now, I think I'll entertain a motion to adjourn.
Thanks. Yeah, it was fun.
All right, all in favor say aye. Aye. Thanks.
I was getting nervous because I'm...
Oh,
sure. Jazz myself up.
That's what was making me. We're still working.